So, welcome back. Today, we are going to go inside your website, and I promise you, there are legal risks hiding in there that most founders have never thought about. Your website is not just a marketing tool, it's a legal document. And everything on it, from the language you use to the data you collect to the images you display, creates legal obligations and potential liabilities. And most businesses are getting at least a few of these wrong. So let me start with privacy policies because this is the most common gap that I see. If your website collects any kind of personal data at all, and it almost certainly does, even if it is just through a contact form, an email sign up, or even analytics tracking or cookies, you're legally required to have a privacy policy. Legally required, okay? It is not optional. California's CCPA and its successor CPRA, which are the privacy rules in California, apply to businesses that collect data from California residents, regardless of where your business is physically located. So if someone in Los Angeles visits your website and fills out a contact form, you're subject to California privacy law, even if you're not located in California. And fines can reach $7,500 per intentional violation. And if your website gets a few thousand visitors a month, that math can get ugly really fast. And this is enforced. So it's really important for you to understand that if you are a business that's operating off of a website and people from California, and there are other states that that have this as well. This isn't just California, but if you aren't paying attention to the privacy policies in other states, you could be in violation of these rules and you're subject to potential fines and enforcement action in those states. So, not just California, but as of 2025, 20 different states have enacted their own comprehensive data privacy laws, each with different requirements, different thresholds, and different enforcement mechanisms. So we're looking at places like Texas, Florida, Virginia, Colorado, Connecticut, and more. And if your privacy policy is just a template that you downloaded from the internet 3 years ago, or maybe it's like the default that came with your template you're using for your website on Wix or Shopify or something like that, it's almost certainly out of compliance with some of them because some of these rules are new, some of these laws are new. And if you do not have a privacy policy at all, you are exposed on every front. And I should also mention that if you have a website, you also risk people from other countries being able to visit your website and interact with your website and potentially buy from you. And so you have to also be aware of other countries' data privacy rules like the GDPR in the EU, which governs all EU countries, 27 countries in the EU. And if you're not in compliance with that, even though you're not located in the EU in any European country, the fact that a European or an EU citizen could be accessing your website puts you within the jurisdiction of the EU Commission and the enforcement actions of any of those member countries. This is something you have to take very seriously, and you need to make sure you are dealing with this proactively. Let's also talk about accessibility because this is another relatively new issue that has real teeth, and it's a current problem that's escalating within the US. But the American Disabilities Act, ADA, applies to websites. You know, when you think of like ADA accessibility issues, generally it has to do with like physical locations having handicap parking and disabled access ramps for wheelchairs, things like that. Courts have consistently ruled that websites qualify as places of public accommodation under Title III of the ADA. And a number of lawsuits over website accessibility have really exploded. 2023 alone, there were over 4,000 web accessibility lawsuits that were filed in federal courts. And those numbers have increased since then. So if your website is not accessible, and there's a specific definition for that, to people with disabilities, including those using screen readers, keyboard-only navigation, and other assistive technologies, you are exposed to litigation. And this is not theoretical. Small businesses, including e-commerce brands selling beauty products and fashion, get sued over this regularly. So, and the typical settlement is somewhere between $10,000 and $50,000 plus the cost of remediating the website. So you have to take this seriously. And again, this is something we advise our clients on all the time. I would just want to, as a side note, say there are websites that claim they can help you with compliance, but the courts have held that they are not adequate. Most of those websites are not giving you what you need to be in compliance. They just sort of put a Band-Aid on it, and they're not going to protect you from these lawsuits. So That's another thing you need to be thinking about. The next is the images you're using on your website. So if you're using images on your website that say you downloaded from the internet, maybe you pulled them from a Google image search, or maybe you grabbed it from someone's social media feed and screenshotted it, you are probably infringing on somebody else's copyright in that image. And I cannot tell you how many times I have seen this. A founder finds a beautiful product photo on Pinterest, saves it, puts it on her website, and then 6 months later, or a year later, sometimes 2 years later, they will get a demand letter from the photographer or the stock photo agency like Getty Images, who is prolific with these types of demands. These companies use what's called reverse image search technology to find unauthorized uses of their images, and then they will send demand letters with settlement amounts ranging from a few hundred to several $1,000s per image. And I've seen small businesses get hit with demands for $30,000 or more because they had a dozen unlicensed images on their website. So the fix is very straightforward for this. You've got to use properly licensed images. You got to take your own photos, ideally, or you got to use photos that come from platforms that offer either genuine free commercial licenses, or you purchase them from a place like Getty Images or iStock Photo, and you buy the right type of license for the way you're going to be using that image. And you make sure you adhere to the terms of that licensing agreement. You download the agreement when you download the photo, and you make sure you follow those terms to the letter. Okay, so let's talk about testimonials and endorsements, because this is especially relevant for beauty, wellness, and consumer brands, but also for coaches, content creators. So if you display testimonials on your website of any kind, and service brands, obviously, this is a big one, the FTC, again, the Federal Trade Commission, requires that they be truthful and not misleading, and they need to be representative of the results that customers can generally expect. So if you are cherry picking your absolute best outcomes and presenting them as typical, as something that is, others can experience, you are potentially creating a deceptive advertising problem. And if you're using endorsements from influencers, affiliates, and affiliates is another one, or anyone who received compensation, or free products, because that's a form of compensation, or any material connection to your brand at all, that relationship has to be clearly and conspicuously disclosed on your website and in your newsletters and even in your social media. The FTC has updated its endorsement guidelines. It was updated in 2023, and they have been actively enforcing them. And fines for non-disclosure can reach $50,000 per violation. So this is incredibly important that you have the right disclaimers if you're using testimonials in your marketing at all. So, okay, let's talk about terms of service really quickly. If you sell anything online, offer any kind of service through your website, or if you allow users to create accounts or have an account or a profile on your website, you need a terms of service. Without the terms of service, you have no contractual framework. You have no contract governing the relationship between you and your users. And there's no limitation of liability. There's no dispute resolution mechanism. There are no intellectual property protections for your content. There's no rules about user content. If something goes wrong, and eventually something always goes wrong, your terms of service are your first line of defense. So without them, you're going to be litigating every issue from scratch, and you may not have remedies for some of these violations, like IP use without authorization. So it's incredibly important to make sure you have a terms of service, or some people call them terms and conditions, that sit on your website governing not just the access to and use of your website, which that's terms of use, terms of service or terms and conditions, terms of sale. This is a separate contract. Generally, it's the one where you have to check the box before you complete a purchase, and it governs the actual transaction and relationship, you and your customer or client. It's important to have a good terms of service or terms and conditions in your shopping cart. This is something I help clients with all the time. And then cookie consents is another one. And this is really important. This goes back to the data protection rules we talked about earlier. If you're using cookies for tracking, analytics, marketing, say you have visitors from California, or you have visitors from the European Union, as I mentioned, you need GDPR compliant cookie consent. That is very specific under that statute. So you basically need to give users the option to accept or reject non-essential cookies before those cookies are placed. And in the EU, under the GDPR, you can't check the consent box as the default. You have to check the opt-out box as the default for them, and then they can move it and check the consent box if they want to consent to the cookies. That is really important to understand because a lot of American businesses will check the opt-in box as the default, and that's actually a violation of the GDPR. And in several US states, as I mentioned before, like California, Colorado, Connecticut, consumers have the right to opt out of the sale or sharing of their personal information, which includes certain types of cookie-based tracking. And also, under both, in the EU in particular, you have an obligation. If they ask you to delete their data, you have to delete it within a certain period of time. And so you have to have the ability to do that. And here's one more thing that people probably miss: product claims. So if your website makes specific claims about your products, like they're organic, sustainable, all natural, made in the USA, those claims have legal obligations and legal consequences. So the FTC's Made in the USA labeling rule requires that all products marketed with unqualified US origin claims, so they're saying it's made in the US, meet the standard of being all or virtually all domestically produced. So California's SB Senate Bill 343 now prohibits the use of the recycling symbol on packaging unless the material meets strict recycling criteria. And if your website says that products are all natural, but they contain synthetic ingredients, you're creating a deceptive advertising problem that might result in class action litigation, FTC enforcement, or both. So my recommendation is this: treat your website as a legal asset. Have an experienced attorney review your privacy policy, your terms of service, your terms of use, and overall compliance with the proper disclaimers and everything else we talked about at least once a year. And definitely anytime you make significant changes to what your website does, what data it collects, and what claims it makes about your products or services. And I know I say this all the time, but every business is different and your specifics obviously matter. So if there's anything in today's episode that hits close to home, I want you to know that I offer a free consultation where you and I can get on the phone and sit down together and talk about your specific situation and figure out exactly where you stand and what your next steps need to be. I never provide pressure or a hard sell. That's not what it's about. It's just a real conversation about your business, your specific situation, and what you need to do to protect it and yourself. So you can book that call on my website, leveragelegalgroup.com. Just go to the contact page and the scheduling page is right there, and get that set up. And I'll look forward to having that conversation with you. And I will see you in the next video.